I've been and hearing feedback from my co-instructors that people are universally pleased to see how well everyone's doing. The learning curve is really coming along, so stuff is happening. It may not feel like that all the time, but you should feel really good about where things are going. What we've done so far is basic skills on examination and cross-examination, including impeachment, exhibits, and trying to get you comfortable with dealing with witnesses on both sides of the issue. Tomorrow, what we're going to do is opening and closing. So at the end of tomorrow, you will have then covered all of the basic elements of the trial, which you will, of course, be running on Saturday or Sunday. So before we get you to do openings and closings in the same spirit as we've been doing this, we're going to demonstrate some openings and closings. And in fact, we're going to do 2 openings and 2 closings on each side, so you can get a flavor of what it would look like in this. Now, what we've asked our counsel to do is not do full openings and full closings because of the time of day, because of how long that would take. So we were really asking for a segment of what they would do, and you can get a flavor of it. The other thing I want to suggest and say is that you'll see 4 different people. We picked 4 people who are particularly good at this, but they all have 4 different styles, and you may like or not like one or some of the styles. You get to decide that, okay? So this is not how you have to do it. They're modeling a way that a person might do it, and you get to pick and choose, okay? So that's important that we remember that. And so we've got Sandra, Sean, Robin, and Pat who are going to act as counsel, and Paul is going to play the role of our judge. So we're grateful to all of you for doing this. Before we get going, to give a bit of realism for them, it's also a useful learning exercise at the end of this, I'd like to again impanel a jury. Do I have 6 volunteers to please come up and sit as jurors for the next 35 minutes or so? Please, yes, yes, yes. Anyone else?
Jonathan,
please.
No. Where's he?
Yes, please.
Jody, yes.
2, 3, 4, 5, and 6. Terrific. All right, Your Honor, it's your courtroom.
Thank you. All right. Just wait for the jury to come in. Floor of jury 26. Okay. Members of the jury, now, if we're ready to begin the case, I will hear the opening argument from counsel for Mr. Ingalls. Ready?
Yes. Thank you, Your Honor. Good afternoon, members of the jury. This case is about what it means to be a lawyer. It's about a lawyer's obligation to represent a client professionally, responsibly, ethically, and never to put a lawyer's interests ahead of the client's, even where that client himself is a professional. My name is Pat Band, and beside me is Robin Parker, and we're privileged to represent Mr. David Ingalls in this lawsuit. He's the plaintiff. Also to my right are Sean Justice Natusuru and Sandra Barton, who represent Ms. Harriet Cooperman, who's the defendant in this case. Ms. Cooperman is Mr. Ingalls' former lawyer. So this is a lawsuit about a lawsuit. Now that might sound a little odd, but it'll make some sense very soon. 4 years ago, David Ingalls was a passenger in his friend Mary Rubin's car. They're both school teachers in Nita City. Mr. Ingalls is married and has a 3-year-old son, Michael. As they were coming to an intersection, Mr. Ingalls pointed out some demonstrators nearby, and this distracted Ms. Rubin. And at that same moment, a truck coming the other way turned left in front of her. That truck belonged to the Acme Paper Company. Ms. Rubin tried to stop, but it was too late. Mr. Ingalls was seriously injured in the crash. He suffered a broken hip, a broken arm, 3 broken ribs, a fractured leg, and his knee was injured very severely. He could not work as a teacher for the next 3 months during the school year. He was in a wheelchair for 2 of those months and on crutches for a month. He'll never fully recover from those injuries. Before the accident, he was an athlete. He'd been a nationally ranked tennis player. He also enjoyed many other outdoor activities. Now it's simply too painful to enjoy those pleasures. Now he teaches class sitting behind his desk. Fortunately, Ms. Rubin's injuries were not serious. But Mr. Engel's injuries caused him significant financial losses. The 3 months off work meant $25,000 in lost salary. He was out of pocket $35,000 for medical expenses. And he lost a contract as a tennis instructor that was worth $75,000. And that was all due to his injuries. When Mr. Engels understood that he could sue to recover from those losses, and maybe even be compensated for his pain and suffering, he hired Harriet Cooperman to be his lawyer. He hired her to sue Acme Paper Truck Company for his lost wages and medical bills and pain and suffering. At the same time, Ms. Rubin also hired Ms. Cooperman to sue the same company. When Mr. Engels first spoke to Ms. Cooperman, she told him that a rough estimate of the settlement would be at about $210,000. After a lawsuit that had taken up to 2 years of Mr. Engels' life, Ms. Cooperman finally recommended that he settle for $100,000. She made that recommendation after spending only hours negotiating with the other side. Mr. Engels is now suing Ms. Cooperman to recover that shortfall of over $100,000. It's our intention, Ms. Parker and I, to prove to you that Mr. Engels suffered this further loss because Ms. Cooperman failed him in her obligation to represent him professionally. Specifically, what we intend to prove to you are 3 things. The first is that Ms. Cooperman did not adequately communicate with him during the lawsuit. The second is that Ms. Cooperman should not have represented both him and his friend Mary Rubin when both of them were in a legal conflict of interest with one another. And the third is that Ms. Cooperman and her firm had a conflict of interest of their own because they had previously represented Acme Paper Truck Company, the company whose driver caused Mr. Engels' injuries. To prove our case, we'll be introducing you to 3 witnesses. David Engel, of course, who will tell you his story and his experience over the 2 years of that lawsuit with Ms. Cooperman. Joseph Doran, who was the lawyer representing Acme Paper Truck Company in the original accident case, will be asking him to testify. He was the lawyer who acted against Mr. Engel. And you'll also hear from Professor Howard Marshall. He's an expert in the field of lawyers' professional responsibility. So first, Ms. Cooperman did not adequately communicate with Mr. Engels throughout the lawsuit. Professor Marshall will explain to you that there are rules that govern lawyers and that they must live up to. Those rules mean that a lawyer has a duty to communicate with her client at all stages of a lawsuit. She has a duty to communicate with her client regularly and effectively. And she has a duty to do that in a timely way. And this is important, Professor Marshall will tell you, because it's crucial so that the client can make informed decisions about his lawsuit. In this case, Mr. Engels will tell you that he spoke to Ms. Cooperman a total of 4 times in the 2 years of this lawsuit. Ms. Cooperman doesn't dispute that, actually. Mr. Engels will tell you that he was interviewed by Pat Simpson, Ms. Cooperman's paralegal, and that during that interview, he and Ms. Rubin told Pat Simpson that Ms. Rubin had been distracted when she was driving just before the crash. Pat Simpson told them that this meant that they were in conflict of interest with each other, Mr. Engels and Ms. Rubin were, and then Mr. Rubin could sue Mary. Mr. Engels could sue Mary, I apologize. But if he did, Pat Simpson told them, then Ms. Cooperman couldn't represent them both. Pat Simpson also told them that Ms. Cooperman could be the lawyer for both of them, though, if Mr. Engels agreed to give up his right to sue his friend Mary. Ms. Cooperman confirms this. But Mr. Engels will tell you that no one told him that by giving up his right to sue Ms. Rubin, he was also giving up a portion of what he could expect in compensation for his injuries. Now, Mr. Engels will tell you that Ms. Cooperman waited until the day she recommended the settlement for $100,000 to tell him two important things. One, that he had performed very badly months earlier during his examination for discovery. And that's when Acme's lawyer interviewed him before the trial. It's something lawyers often see as a dress rehearsal for trial. Second, that it was important that the accident had been partially caused by Mary Rubin's distraction, and that Mr. Engels should have sued Mary if he wanted full recovery. With respect to Mr. Engels' poor performance at discovery, I anticipate that Mr. Doran, who was the lawyer who had asked him questions that day, will tell you that Mr. Engels' poor performance was one of the 2 breaks Acme got in that case. I also anticipate that Ms. Cooperman will admit that Mr. Engels' performance at his discovery was one of the 2 unusual things that had occurred in her case as she represented Mr. Engels. But Mr. Engels will tell you that Ms. Cooperman had never told him anything negative about his examination for discovery until the day she encouraged him to settle for $100,000. With respect to Mary being at fault for the accident partially, Mr. Engels will tell you that Ms. Cooperman had never explained to him that he could only get full recovery if he sued Mary. And I anticipate that Ms. Cooperman will tell you that she didn't know that Mary had been distracted during the accident until a few months before the settlement. If she does tell you that, I expect you will be very interested in looking carefully at the notes that her paralegal, Pat Simpson, took of her first meeting with Mr. Engels and Ms. Rubin. Those notes have already been filed in this trial as Exhibit 1. Number 2, Ms. Cooperman should not have represented both Ms. Rubin and Mr. Engels. So I would go on to number 2 and explain our thoughts about that. And once I'm done that, I would come back at the end and say the following. Members of the jury, at the end of this case, after hearing all the evidence, Ms. Parker, my colleague, will return before you and ask that you find in favor of our client, Mr. Engels. She will ask you that you find that Ms. Cooperman was negligent in her representation of him, that she breached her professional duties to him, and that accordingly Mr. Engels is entitled to the damages he would have received had Ms. Cooperman represented him appropriately and professionally. Thank you.
Thank you. We'll now hear for counsel for the lawyer, Ms. Cooperman. Mr. Nakasura.
Thank you, Your Honor.
You said that again.
Thank you, Your Honor. Members of the jury, September 8th, 2010. Mary Rubens and David Engels walked to Cooperman and Jones. The defendant, Harriet Cooperman, was in her office that day. She was busy, hard at work, doing her best to offer her services to her clients, or many clients, and help them with the legal troubles that they have. Harry Cooperman will testify, and I anticipate, members of the jury, that she will tell you that on September 8th, that day was a day very much like any other day in her long career as a lawyer. First of all, as an assistant crown attorney, offering her talents to the public service for a number of years, then as a junior associate at the venerable firm at Marks and Mayfield, learning the ropes of civil litigation. At that firm,